Hello, everybody. Thanks very much for joining, and thanks very much for the Reunite New Zealand crew for getting together. Tonight, we have a very special guest on board, Erika Whittome from the Number 8 Workers Union, and we're going to be talking a few legal matters, employment matters with Erika. Erika, welcome to the group, and yeah, if you don't mind introducing yourself and the Number 8 Workers Union to the viewers.
Sure. Thanks, John. My name is Erika and I volunteer for the Number 8 Workers Union of New Zealand. It's been around for a couple of years now, and we have been helping a lot of people who could not afford to pay, 10,000, 20,000 plus to their lawyer to take a personal grievance, to take a breach of contract, to raise disadvantage during their employment, all these things that have been happening since our wonderful government forgot the rule of law. So the rule of law is, when you have primary legislation. I mean, this is just I'm no expert on this, but obviously from the last few years, we've all had to read quite a lot and get aware of what's been going on with our laws and with our rules, and how there is not law made just on the television set, the same way this Zoom is not making law either. We're just sharing information. So the Number 8 Workers Union has been helping people use the Health and Safety at Work Act and obviously the Employment Relations Act in order to raise grievances and breach of contract claims with their employers for coercing a medical treatment on them in order to keep their jobs. So this is a snapshot that I've put together recently. I'll try and share that now. We've had quite a few cases filed. If you look down to here where it says cases settled, 41, most of the cases that the union has taken have been settled in confidential terms, which means that it's not on the public record, and the employer didn't want it on the public record. Obviously, that's why it's been settled. But it's interesting that that's the biggest number on there, 41. We've had 6 wins in the Employment Relations Authority. That's what ERA stands for, and the Employment Court. Mediations, we have mediations happening all the time. Mediation is a process that's informal. There's no judge, there's no evidence. It's sitting down and trying to resolve the issues and come to some kind of arrangement or a settlement. These numbers in here sometimes end up in the cases settled box, and if they don't get settled, then they go to the Employment Relations Authority or the Employment Court. Newly filed, we've put in 35 cases in the last few months, mainly because of the 3-year I don't really want to say anniversary, the 3-year date from the 15th of November when people were told that they weren't allowed to visit their workplaces unless they were vaccinated. What's a better word for anniversary? Anyone got any ideas? Memorial?
Memorial. Yeah, that might be more applicable.
Yeah, we've got 10 cases filed in the Employment Court. The number of law firms that we've encountered that were listed on Ursula Edgington's Substack the other day. Brian, you had a question. Oh, you're on mute.
Brian?
There we go. All right. I was interested in why were the 41 settled cases confidential?
It's just part of the settlement process. So there's a mediation. At the end, there's an agreement drawn up, and that's just how settlements happen.
Who doesn't want the public to know?
Who doesn't want the public to know? Well, normally the employer, right?
Thank you.
Yeah. We have done a couple of non-publication requests for some of our members when they've gone to the Employment Relations Authority, and one of those settled before it even got there. So it's normally the employers who don't want their name on the record.
In your
Uh,
opinion, were they undersettled?
Were they undersettled?
Yeah, did they sell out
I think
too cheap?
as time goes on, the amounts are getting higher and higher. So 2 years ago, they weren't very much. There's been a lot of other cases in the Employment Relations Authority and the Employment Court, and the amounts for hurt and humiliation and lost wages look like they're going up and up and up. We're not in USA where it's, $1 million, $2 million. We're not those kinds of figures. And often the awards in the Employment Relations Authority are around 3 months' wages anyway. So those are the sorts of amounts, I mean, average, generally speaking, that people get for a work-related issue. So the law firms encountered by Ursula, I'm not sure if you guys read her Substack, but she made a list of the lockstep lawyers that have been acting along with our wonderful friends in the Labour Party and Pfizer and the other drug firms, the kind of drug mafia that's going on, pushing people around. And 7 of those we've encountered already in the Employment Relations Authority filings or the Employment Court filings. And the last number is the number of other unions filing vaccine mandate cases. Well, I haven't heard of any. So if anyone's got any, please do let me know.
Well, Erika, if I could just intervene there quickly. As you know, I'm a union delegate and a convener for New Zealand's largest union. And
Yes.
I can tell you now that they do not. They have not backed one person against these jabs or the discrimination and people losing their jobs. It's absolutely despicable. And for the record, that is right. Number 8 Workers Union, as far as I know, is the only union who has taken a stand. So, yeah, good on you.
Thank you. Yeah, if anyone hears of any other unions, I haven't listed them all here. We've got engineering unions, manufacturing unions. Yeah, I won't list all of them, but those are the big ones there. And we're going to be busy for probably at least another 3 years because the time limit for breach of contract is 6 years. And I've yet to see an employment contract that says a person will take vaccinations as part of their contract with their employer. A lot of employment contracts say that the employer will follow very strictly the Health and Safety Work Act, and that's really a big bonus for us. Susie Wiles got $20,000 out of the University of Auckland because they didn't follow the Health and Safety at Work Act and keep her workplace safe. So thanks, Susie. One good thing for those people who want to follow the Health and Safety at Work Act. And she didn't even get fired. She just made complaints that she didn't feel safe when she was at work.
Okay.
So one of our other cases that we have is Mr. Young, who filed a personal grievance against his employer, and this is under the Whistleblower Protection Act. I can talk a bit about that because the Act got changed in 2022 in July. Now I'll stop sharing this and I'll bring that one up, which is application windows. Just bear with me a moment. And I'll get rid of these cat things because my daughter loves cats. Hang on a second. There we go. Can you see that now? Protected disclosures. You can't see cats, all right? Good. This is the Protected Disclosures Act. So it's whistleblowing. And who does it apply to? Well, we'll go down here first. I think this is something that's been added in the 2022 update. It used to only be people who were working for a company. So this is the meaning of a disclosure. So the disclosure is the person who reveals the information. So it can be A, an employee, or B, a home worker. That could be, a support and care worker, someone, or, a nurse support worker. A secondee to the organisation, that would be, say, a board member. So someone who doesn't have an employment contract, but they're in the board. A disclosure can be engaged or contracted under a contract for services. So that would be a contractor for an organisation. Concerned in the management of the building. Management of the organisation. So this is again someone in the governing body of the organisation. Member of the armed forces. So that means people in the military, and a volunteer. Now, this is what's interesting up here. It says an individual who is or was formerly.
Oh.
So if I did work 4 years ago for the Ministry of Health, for example, I would still come under this category because I was formerly, perhaps I was an employee, or perhaps I was in a contract with them. So the coverage is very, very broad. It used to just be people who were workers, but as you can see, if you're a contractor, you can also make a protected disclosure about an organisation. The next thing I wanted to go over was the meaning of a protected disclosure. So the meaning of a protected disclosure: a disclosure of information is a protected disclosure if the disclosure believes on reasonable grounds that there is or has been serious wrongdoing in or by the discloser's organisation. So in the case of Mr. Young, he believed that his organisation was doing something wrong, and so he disclosed that to his senior leadership team. Discloses information about that in accordance with this Act and does not disclose it in bad faith. I'll go back to the section about how you actually disclose. So you don't go on your Twitter account and go, I think someone's done something wrong here. You have to actually go through proper steps. Let me just see where it is. Oh, I think it's whom you disclose to, meaning of appropriate authority. So the head of a public sector organisation, that would have been the leadership team, for example, at Health New Zealand, includes any officer of Parliament, includes the persons or bodies listed in the second column of Schedule 2, includes the membership body or particular profession. So that could be the nurses organisation, the chiropractic organisation, the osteopathic organisation, any organisation like that. And does not include a minister or a member of Parliament. So there's a difference between an officer of Parliament and a minister or a member of Parliament. And I'll just jump to Schedule 2 because this shows, for example, if I know the policeman's doing some bad stuff, I am to disclose to the Commissioner of Police or the Director of Serious Fraud Office. Like I said, I don't just go on Twitter and make a big statement that, Constable Brown has done something wrong. There's a certain person to talk to for each different areas. So down here for health, we've got the Ministry of Health and the Health and Disability Commissioner. For health and safety, we've got Ministry of Business, Innovation and Employment and WorkSafe. And does anyone have any questions? Oh, Geraldine, you got your hand up.
Yes, sorry, Erika. The first, I see the first amendment they've made in the first schedule where they are defining, actually, where was it?
Meaning of disclosure.
I think it was that one, yes.
Yeah. Disclosure, sorry. Yeah.
Why do you think they broadened that? I mean, if you look at it, it's almost they're picking a rod for their own back, really. Or why do you think they've changed that? What do you reckon?
I have no idea. And in 2022, I can't say I was watching legislation going through in July.
Yeah.
I think it's obviously a good thing.
It's good for the people that need to do it. It was just, you always wonder why they make amendments to legislation, especially when they broaden certain meanings and certain references in there, you kind of wonder, they're doing themselves a disservice, really. For us, it's a good thing. But I was just wondering, I wonder why they've done that. But okay, no, fair call.
I think maybe it's based, often some of these laws are based on the Australian one that's going in or the British one that's going in. They're not doing themselves a disservice. They should be allowing for more transparency and wanting to do proper service for people.
Well, yes, I mean, that is our opinion, but definitely not theirs, is it?
Well, yeah, I mean, the point of this is if you have a problem, then you're to talk to your senior leadership, and start to work it out. Brian, you had a question.
Okay. It's undoubtable that harm has been done, and only today the justice system in America has ordered that another 1 million pages of the FISA documents be released, which was supposed to be hidden for another 75 years. The government will undoubtedly attempt to pass the buck and eventually onto the employer and the small employer. And this whole thing traces back to the WEF and the WHO. Now, they need a scapegoat. So I'd like your opinion on that. There's already been a public statement by Chris Hipkins, and I've seen it reverberated around the world. We did not mandate anybody. Your opinion, please.
And that is 100% correct. If you look in the vaccinations order, duties of relevant PCBUs, this is clause 8. A relevant PCU must not allow an affected person other than an exempt person to carry out work. There were always exemptions. So when Chris Hipkins says no one was forced to do it, the PCBU could make people exempt. There were 11,005 exemptions that were given out to health workers. And if you go down here, there were clauses under here. This is clause 9. I mean, this is not the latest version. These are versions from before. We could talk about this act for hours, and it's really a matter of the fact that employers didn't read it. They watched television and got all their advice off TV or MB brochures that are not law. This is what the law is, and this is what we get to take to the Employment Relations Authority and to the Employment Act. Sorry, to the Employment Court. This is clause 9. Chief executive may authorize affected persons not to carry out certain work. So the person in charge could always make someone exempt. The issue is that no one ever read these. I shouldn't say no one. Liz Lambert read all of these
Yep.
back in 2021. And your comments on the WF and the WHO, well, they're not elected officials in our country. The way we're going to get to these employers is by picking off these workers' issues one by one. There's no way to cut off the head of the snake just with a single sentence or with a certain single piece of law. We're talking about capture across a lot of government organisations, and they've all just turned into Pfizer marketing drug reps, in my view. What they need to do is go in and start doing some reading of the legislation, and then they can use the legislation. So I'll go back to the Protected Disclosures Act, which was one of my tabs up here, this one. So we talked about the fact that it's people in the past who have worked there, and then guidance what the receiver should do. And I think there's something in here about the fact that it's a personal grievance as well. So this is on legislation.gov.nz, and then you just do a search in the title for protected, and then you get the legislation come up. I'm sure there's something in here about a grievance. There we go. No retaliation by employer. Okay, so if I go and tell someone at the Ministry of Health where I say I used to work, that something bad's happened, my employer is not to retaliate. So that means, coming after you, sending the police around, maybe with some armed defenders, confiscating your personal property, perhaps, throwing you in jail. You're not to retaliate, because if you do, then that's a personal grievance. So if you say something to your employer and they go, all right, you're out of here, Erika, you're fired, then there's your personal grievance right there.
Gosh, have you had any cases using these laws, Erika?
Yeah, we're doing one for Mr. Young.
Okay.
That was filed in June. What are we now, December?
Sorry,
so
is that very young?
Yeah. So it's not an overnight process, as you can imagine. A recent decision that we got was for the Maori Women's Welfare League. That was filed in May of 2022, and we got a decision about 2 weeks ago. So it does take a long time to go through the process of the Employment Relations Authority or the Employment Court, which is why mediations are so prolific. They're normally organised within a few months. It's all done on the day, and you're not waiting months and months for the court system or for the Employment Relations Authority. The wait right now for an investigation meeting at the Employment Relations Authority is about 6 months.
Wow. And it's I suppose that's only getting worse, because I know they've been flooded with cases.
Yeah. I think prior to all of this, pushing the medical treatment, it still was slow. Employment court decisions still take a couple of years, and the Employment Relations Authority. That's just our justice system. Unless you go and murder someone down the road, you're not going to find yourself in the court on the weekend, kind of thing. Employment stuff doesn't get the same priority as, crime, because that's, community danger, I guess, if you're letting these people walk around.
Mm. Okay, I see, Tanya, you've got a question.
Say Barry's got this court case that's coming out, but you've got this employment grievance coming up for him, does that hold off the court case?
Oh, so he's got his Employment Relations Authority filing, so that's using this, whistleblowing protection and personal grievance.
Yeah.
And then he's got, and then there's the criminal side of it that's completely different.
I just wondered whether, because this case was happening, whether that would be the case, but it's kind of almost like a leverage. Interesting.
So yeah, one's in the Employment Relations Authority, and if that's not successful, it goes to the employment court. Whereas the other charges are just in the district court. So that's the Crimes Act. And the union isn't across that aspect of it. The union's just helping workers with employment issues.
Mm-hmm.
Like unions are supposed to, right, John? You too?
Yep, I know. Look, for the better part, they do a good job. They still perform a very valuable function, but they've never gone down that road like Number 8. And I mean, my involvement with Number 8 Workers Union was with Liz Lambert and a name Forrest. Forrest.
Forrest.
Yep. And with Section 83s, and where I was working at the time, Winstone Wallboards, we were issuing Section 83s wholesale. So yeah, I'm wondering, have you had many cases that years down the track where people issued Section 83s that it's actually kind of turned around into a personal grievance type of thing?
Yeah, so yes, we just had a decision last week, and it's taken a long time. This person sent in a Section 83 letter before she was fired, and it went to the Employment Relations Authority, and the Employment Relations Authority said, no, that's not a grievance. And so it got filed in the employment court. So these are various tiers of escalation. You have the Employment Relations Authority, then you have the employment court. The Employment Relations Authority was set up to be an informal process without a court setting, you know, to have matters looked at. So it went to the employment court in September, and we just got a decision that yes, it is a grievance. So everyone who sent a personal grievance letter, I should say, to their employer has raised a grievance, and that's what's called a disadvantage grievance. So it's before you're terminated, you're saying, hey boss, something's not quite right. I don't like what you're proposing for my workplace. It's different than getting fired and then sending a letter and saying, hi, I've got a personal grievance because you fired me. So there's two things. There's disadvantage, and then there's a unjustified dismissal for being fired. So yeah, we've had through the employment court now, we've got a judgment that says a Section 83 letter is a disadvantage. So yeah, we'll be using that when we go to mediations. And any other talks with these employers. Ray, you had a question.
Yeah, surely what's going on with Barry Young, surely that's all coming under the whole retaliation thing with what they're doing to him now. That's blatantly obvious what's going on there.
Yeah.
Cool. I just want a clarification on that, sorry.
Yeah, it's so the sending the police around to your house, it's not what my boss ever does to me. There's definitely retaliation. That's not only you've made a disclosure, but we're going to seize all the equipment and everything associated with it.
Do you think that was sending a message out saying don't do this, you know?
Oh yeah, and they got orders on the weekend from the employment relations authorities to say no one's allowed to talk about it either.
Oh, interesting. Wow.
Yeah, but I question the employment relations authority's jurisdiction there. You know, in particular.
Yeah, they don't unless I mean, I don't work for the Ministry of Health, so I can say whatever I want. It would be if one of us worked for the Ministry of Health, then we wouldn't be allowed to talk about it. You're right, John. They don't have jurisdiction. And when they said things to Americans to take down the site, it's like, well, why would they listen to you? The CEO of Rumble said, well, no, I'm not doing anything of the sort. You know, freedom of speech. Go jump in the lake. That's basically what he said.
I think the medical profession they've got their own kind of employment issues. Like I know there's the nurses union, and there's lots of issues with that. The midwifery union, and they're quite separate to the employment union in a lot of cases, but they still fall under these employment contracts.
So they still come under who? Let's go back to this.
I'm just sort of going back to my friend who was a nurse at Waikato, and she got treated appallingly, and I sent her to my lawyer, who is an employment lawyer, to try and get something sorted for her, and she was all on board until she said, where do you work? And she said, Waikato Hospital, and she backed right off.
Who backed off? The lawyer?
Yeah. She said they've got their own.
Well, maybe they had a conflict of interest. Maybe they were.
Yeah, they tried to make her sign a contract not to talk about the terms of what happened. Yeah.
So it can be an organisation. For example, you know, I've seen my fair share of alternative health people over the years. You know, osteopaths, chiropractors, acupuncturists, and what I found astounding was that their organisations were saying, go and take a injection of a pharmaceutical product. And to me, that's a complete contradiction of their own code. And I would love to hear about one of those organisations and having them, make a disclosure that what they said to their members, you know, you have to do this, otherwise you can't be a naturopath. Or actually, I don't know if the Naturopathy Association did it, but do you see where I'm coming from? All of these associations for for groups that don't follow pharmacy, and then all of a sudden they were told to jump on board.
Because it's all based on holistic natural health, and yet they turned around and did exactly the opposite.
Yeah. Oh, Ray.
So if it is proven that the employer is retaliating, where does the law go from there? Like where does the employer get pushed to from there? Does it come under criminal law from there, or civil law, or?
Oh no, it just goes under the Employment Relations Act, and it's a personal grievance. So it's the same personal grievance as any kind of problem that you're having in your workplace, and it's under the Employment Relations Act, right?
Okay, so in relation to that, is there obviously going to be some kind of cap as to what people can be compensated, or can they be compensated whatever is deemed appropriate? Because a lot of these corporations out there, they're not going to care about a $10,000 payout when they've made $100 million from something, you know?
Well, it costs a lot to get to the Employment Relations Authority. You've got to file, you've got to do a lot of written documents. I think I saw one letter where a lawyer was saying it costs the firm $30,000 just to get into the Employment Relations Authority, you know, to do the written paperwork, to do witness statements, to do evidence affidavits, written submissions. There was a case at Melville High School a couple of years ago for some counsellors who worked there, and they did a claim that wasn't a personal grievance. They did a breach of contract claim, and their payout was 1.7 million, I think. So it really just depends how you quantify what your salary impact is, and if you had to take all your money out of KiwiSaver, or if you had to sell your house, or I mean, everything has to be quantified, and it's on a case by case basis. There is no kind of checklist or a generic checklist, is what I'm trying to say.
Yeah, cool. That's what I wanted clarification on, because I know a lot of people are going to be thinking, oh, what's the point when these companies, you know, they're going to pay $10,000 and what do they care when they make 100 million? That's what I thought I'd ask.
Yeah, so if they have to pay 10,000, the recent case from the Maori Women's Welfare League, that worker got 28,000 hurt and humiliation and 3 months' wages, and their lawyer probably charged about the same in legal fees to get there. Right, so that's gonna show up on their financial statements, legal fees, personal grievances. The board is going to go, what's all this money being spent? This is what happens on financial statements and annual reports. You know, all the expenditure has to be justified. So if your company's forking out lots and lots of money for this, and you could have settled in the mediation much early on, then I'd say there should be some hard questions asked. And you know, even better is for these employers to just do some kind of reconciliation right from the get-go, but we're still waiting for that. Lisa, did you have a question?
Yeah, it was more around, would you see the employers going the government later on for, or
I hope so.
Have they been tricked? Because the thing is you've got so much harm being done here across society. You know, even if some of these people were mandated out of jobs unfairly, and they get their cases heard in the next 3 years or so, but we've got massive harm that's happened across. It just goes so deep, and you've got employers, you've got the families of people who split up basically during the process of all the mandates and lockdowns and everything, because of the amount of stress that all of this has put on them. I mean, yeah, just an opinion would be good.
Oh, I think that employers are going to start realizing that they got rubbish advice, and that there was a decision, was it last year, in the employment court for Port of Tauranga, and the port decided that this particular person was, I can say about this one because there's gonna be a published decision any day now. The person they thought came under the order that they had to be vaccinated, that their role was a person that needed to be vaccinated. and they got advice from someone from the Ministry of Health, and the advice was that this person came under the order, but the Judge Holden said advice is not legally binding, you know. I can say to John, if you come around and visit my house, you have to take your shoes off. That's my policy. I can exempt you from the policy though, John, because it's my house. But this is my advice, that I want you to take your shoes off. And then if you don't take your shoes off, well, you're not going to be my friend anymore, John. That's it. It's over. Because you didn't follow my advice. You know, it's just so ridiculous. We don't live in a society where we follow people's advice and then take drastic measures when they don't follow it. And this is a case where the judge said, yeah, advice is not legally binding. So all these employers will soon realise that they got terrible advice from lawyers and from WorkSafe and from MB, and hopefully they'll start trying to get some kind of outcome from that, or some accountability from that advice. The CEO of WorkSafe resigned last year in September. Anyone remember?
Yep.
And then the interim CEO resigned again from WorkSafe in April. So it's a bit of a hot seat, really.
Yeah. The other question I had, Erika, was on exemptions. I know so many people who tried to get exemptions, but that seemed to be a very messy, subjective area, and yet we find out later on that there's 11,000 exemptions that did get given at the very high end, and we're not allowed to know who those people are. And I think that we need to know who those people are, because it would, once we get the Pfizer contract release and matching up these other things, I think we're going to get a very clear picture.
Yeah, so the exemptions before, what date's this version? This is the 20th of November. I think it was the 6th or the 7th of November, they went and changed it, because it used to be that you could just go and get an exemption from a health practitioner, right? So that could be a social worker, a pharmacist, a doctor, anyone who's a health practitioner under the Health Practitioners Assurance Act, I think is what the definition is. So if you're in some kind of body, and yeah, it wasn't just doctors. I think it probably included chiropractors. Now, this was under clause 7. Duty of affected person. Oh, sorry, I might have the wrong version here. 7A. Here it is. A suitably qualified health practitioner, right? And then this was replaced at 11:59 on 25th of October. I think on the 6th of November, that's when they changed it, and they said it's all ending, and now it's going to go through the Director General. But the thing is that legislation isn't retrospective. So if you had a 7A exemption prior to the 7th of November, was it 11:59, something like that?
Yep.
Then that was still valid, because legislation's not retrospective.
Right.
For example, homosexuality, when was that no longer illegal? The 70s, the 80s? I'm not sure the exact date. So they changed the law, right? They're not going to go back and prosecute people in the 1960s and go, all right, you had homosexual activities back then, we're going to prosecute you. So the law is not retrospective. So the same applies to this. At the time, the exemption was valid, and you can't go back in time. You know, all those people in California that watch Cheech and Chong movies now, they must just be laughing, because, you know, you can just buy marijuana on any street corner, or I shouldn't say any street corner. There's all kinds of shops. No one's going to go back and prosecute Cheech and Chong for what they did.
True. So the last question I had is about compensation. So if, say, employee get some resolve with a case with you right now, and yet we come to a situation where the government is held accountable for all the harm that they've done to the entire country and everyone gets compensated, would they miss out or would they be included? What would be your
I don't
opinion
know.
on that?
I mean, when you say the whole country will get compensated, I have no idea how that would work or what kind of law is being proposed. Yeah, the devil is in the detail, really.
Yeah, okay. I guess it comes back to, well, as things unfold and we find out what we know, but it becomes more easily provable, then I guess we'll tackle that then, because a lot of people have been harmed a lot.
It's kind of like, you know, the tax credits when they go, oh, everyone's getting a tax credit, but it turns out you've got to punch in this and punch in that, and it's only for this and only for that, and then you go, oh, okay, well, I'm getting about nothing. You know,
True.
it's not, it's the devil's in the actual detail. South Africa had a truth and reconciliation process. I don't really know much about it other than the fact that it was a fast track method to help people. John, what do you know about it?
Yeah, look, that was immense. I mean, that carried on, gosh, it carried on for years, actually. And it was daily. Everything was public. So it was held in, public arenas, town halls. It was televised. There was transcripts made. So it was really done professional. And look, a lot of good came out of that because people could actually speak up for once and not be persecuted, number one. Number two, it also did bring a lot of criminal activity to light and highlighted that. And that was dealt with separately. Obviously, as people were implicated, that was taken off one side into the criminal courts. And so, yeah, it's a very good thing. And we need that, yeah. I mean, to be fair, even this phase 1 inquiry that came out, I mean, I did a OIA months ago on Tony Blakely, and man, the conflict of interest there is insane, and I knew from the get-go that this was just going to be one big whitewash. And, yeah, they've released the 713 pages of exactly that. There is some things they admit, but yet what's happening? Nobody's being taken to task. Nobody's been persecuted. Nobody's being investigated. It's worth nothing.
Well, so there's a phase 2 and all the phase 1 people are no longer with us.
Yeah.
I mean, sorry, they're not no longer with us. It's they don't have those positions anymore. So that's one good thing, is that a phase 2 came about and there were new terms of reference, because you helped expose that, John. Obviously it was an election thing for Mr. Peters about the COVID inquiry. Public interest is what's going to get these things happening. The union puts its court cases and ERA cases on the Facebook page. These things are public events. So, John, you mentioned the Truth and Reconciliation being public. People want justice. They need to start going and watching it and seeing it happen, and start going to courthouses and start going to Employment Relations Authority.
That's right.
Because, there's been all these high court reviews that have been happening for the last few years, and it's different trying to go straight to the top as opposed to, getting the little people down on I shouldn't say the little people, the employers first, right? Because the employers, I feel sorry for them some of the time. When they say, oh, we were just doing what WorkSafe told us to do, and we were just doing what MB told us to do. Eventually they'll connect the dots. For now, they're still in kind of COVID kindergarten, still figuring it out.
In the same breath, it's sort of like they also got fined and taken to court, employers.
Fined. And that's a very good question. That's a very good thing to talk about, because I've done a few OIAs about who got fined, and not very many.
Really? They made just a public example of some, I think.
Of
Steve
course,
Glover,
yeah,
did
yeah. I did an OIA to WorkSafe. I said how many people got fined and how many have you collected, and it was hardly any. I think they'd collected, they claimed they'd written out fines for several $100,000, but they'd only collected a few thousand.
Well, and yet they threatened all employers.
Exactly. And same with, I've seen so many letters from principals to school teachers saying, you're not allowed on the school grounds after the 15th of November, or there'll be big trouble. And I did an OIA to WorkSafe and said, how many educational facilities did you go and issue fines to? And the answer was big fat 0. So yeah, exactly like what you said, Tanya. It's scare tactics. Remember, there was that couple who went on holiday in Wanaka, and you know that's the public humiliation. That's putting the person out in the stocks in the town square and throwing tomatoes at them. So you go, all right, don't you do any more stealing or anything, or you'll be made an example of. If you look up my name on the FYI website, which is the OIAs, you'll see those OIAs where I've asked how many fines were issued and how many have been collected and how much they're spending trying to collect them. That's another wonderful use of taxpayers' money. But yeah, the fines has all been smoke and mirrors, just like when, you know, Dorothy goes behind the curtain and Toto the dog bites the guy's ankle. When he goes, don't come in here, don't come in here.
Don't look. Yeah, I think
If you don't see a man, don't talk to that man.
I was quite fortunate in that I wasn't. I'm self-employed, but I had an accountant who was like, you can have all this, you know, and help me survive, because theoretically I wasn't allowed to work because being a hairdresser. So at the time, so at the end of the day, I can't say that I struggled a lot, but my client base left. So when I could get back to work, I had very, very minimal clientele, which has taken me years. Some of these people have been 20 years, had gone. My business was not even, well, a third of what it was, if that. And when it came to that next financial year after it was called sundries. And I was taxed on all that money, some of it, good portion of it, and it was a huge tax bill.
Is that on the subsidy you're saying?
Yeah, and all the subsidies that Jacinda, some of them that Jacinda was handing out, yeah. So a lot of businesses got hit quite hard afterwards too. So it was really messy, what a con job.
Yeah. Oh, these are all the fines that were, there we go, 70 infringement notices have been issued to date. The total monetary value is $442,900. One fine has been collected of $300. And as you know, Steve Oliver was taken to court. I don't know. He paid a lawyer for quite a while, and then WorkSafe mysteriously dropped all the charges.
Yeah, that's right. I actually seen Steve 2 weeks ago, and he said, yeah, all that stuff has been dropped. Every single thing, they dropped it all. But like you said, all that smiled was the lawyers.
Yeah, exactly. And look how much he would have had to have paid the lawyers. It's just
and that's where there's the opportunity to do a counterclaim. So you go back to WorkSafe and you go, you've destroyed my business. You've given out advice that wasn't necessary. You know, where are the undertakers on the street carrying away all the dead bodies? Where's this risk? Where's my workplace risk? I don't know who put the hand up first, Brian or Mr. Dobalina. Mr. Dobalina.
Definitely Rob.
Yeah, Brian's had enough to say already. Hey, as an employer of a 25 staff in a restaurant through that, I can say that you know, I was very much open to my staff not participating in what was deemed necessary. But on the flip side, so my management staff actually said, look, that's not really fair for you to do that. We all rely on our job. We need to do this so we can play the stoplight game that Jacinda and her cohorts invented. So I had a meeting with my staff, and I knew there was a few that had not gone and got jabbed. And I basically just said, look, this is my stance on this. You know exactly how I feel about it. I've been pretty open about it the whole way through. my stance is not changing, but as it stands with the stoplight thing, the managers have decided that if we were to stay open, that we would all need to be legal. And I said, even though I know that legislation isn't law and it only becomes law when your workplace says so, but I said, if this is your out, I understand. I said, I'm not going to be hypocritical. I will tell you that I'm not going to be doing this. But yeah, if this is your leaving, then yeah, that's for you to decide. I will not hold it against you at all. So there was some employers out there that were awake, but like Tanya said, the gift of keeping your business going was really hard. The fact that the staff, the full-time staff, their wages got annihilated, like the $518 minus tax when they're earning over $1,000 a week in the hand because of what they do. It was just a kick to the guts. The only people that came out with it being kind of semi-normal were the part-timers that were pretty much getting a normal week's wage given to them by the government. But yeah, it was really, really hard. It was hard to get through. It was hard to get out of. The customers, obviously, it was quite difficult for them as well. So yeah.
this is one of the big smoke and mirrors that went on. This is the protection framework legislation, which you can find it if you Google it, but it's it says a business must comply with CVC. So CVC is short for COVID vaccine certificates or non-CVC rules, right? There were two sets of rules. There were stick up those signs and ask for vaccine certificates, CVCs, or you can put up a sign and say that you're not going to do CVC rules. Now, I think I saw one business in Taupo where I was during that time that had a non-CVC status sign. So it was a sign that said, we're not following this, and this is our status, non-vaccine certificate requiring, something like that.
Yeah.
And then it said a business must have processes to check it. But the fact is, it was an option. And this goes back to Mr. Hipkins saying, oh, everyone had a choice. And people didn't have to be vaccinated to go to restaurants, right? You just had to either display that you wanted CVCs or that you didn't want CVCs. And wonderfully, MB did not really make that very well known. You could still download the signs, and same with WorkSafe. So yeah, eventually these businesses will get together and go, this was our loss of revenue. We got this advice and that advice. And if you had a WorkSafe officer visit you, then even better. Because you'll probably have a record of their officer number or their badge or something.
I've sold the business about a year and a half ago. I've been cleaning up silt in Hawke's Bay, but anyway, that's another story.
Oh, Brian.
Okay. I believe that the COVID lockdowns were just a test run, as many of us do. So there's a lot more coming ahead of us, and this is just the beginning. Your work is actually imperative to the future justice of all workers. Now, I think an OIA asking for the exemptions to certain demographics would be allowed. I mean, they won't say anybody's names of who have been exempted, but if you put it in the terms of a demographic like politicians, health workers, then I think they would have to release it.
Yeah, I've done a few, Brian. I've done, I mean, there's, I don't know how many different government organisations. You've got to ask each one individually.
One question at a time is what I've found.
Yeah,
with
yeah.
OIAs. Okay. When it comes to compensation, the ironic thing is that we are the taxpayers and we have to compensate ourselves.
Mm-hmm.
So, the non-investigations that are occurring now, I claim, are also part of the test run. Your opinion, please.
So what do you mean by non-compensations?
Non-investigation. Like they're
Non-investigations.
not
What do you mean by that?
investigating anything, but that's also part of the test run to see what they can get away with next time.
So sorry, what do you mean by non-investigations?
Well, they're refusing to investigate the wrongs that have already been done. They're making it so hard for anybody to get justice by using up their resources and their time, and they're just making it so hard for anybody to claim against them that they're psyching us out already for the next. I mean, they tried monkeypox and was laughed out of the street, you know, but
They tried making what?
monkeypox.
Oh, monkeypox. Yeah, I mean, you know, there's the TV set. I switch it off. I don't listen to it. The TV is about here's some local news, pay your taxes. Here's some international news, pay your taxes, so that we've got an army. Here's some sport news, pay those taxes because Sport New Zealand got to pay all those other groups. A kitten fell out of a tree and a couple of movie stories. That's the news. It's the same every single night. Scaring about monkeypox this and varicella that, and God knows what other disease they're coming up with. I compare this to, say, the leaky building issues that happened in this country for decades. It takes years to go through the court system. We don't hear about as many leaky buildings anymore because people slowly, well, the developers and the people vested in the building industry began to wake up and go, oh, we can't just get, we can't just get Jane Doe who says she can do tiling in to do membranes on rooftop patios. We better get some trained people. So it's not going to be an overnight thing. There's not going to be flyers dropped from airplanes saying the COVID war is over and the disease was all a hoax and it was less than the flu. It's going to be quiet resignations for a number of years, similar to what a lot of Eastern European countries had. I think the only country in Eastern Europe that really had a big revolution was Romania. They went and shot their dictator on live television. All the other countries, it was a very slow process, slow resignation, slow transfer of wealth from the state back into private ownerships. I mean, the state in New Zealand owns so much. They've got their fingers in everything, and they're slowly going to have to start pulling their fingers out of everything because no one's going to want them. They don't want state interference. So, the best thing you could do is don't listen to the WHO, don't listen to mainstream media. There's an alternate universe that's happening. It's already happening in the US. There's going to be accountability for Mr. Fauci, what he's done. There's going to be accountability for the Vaccine Injury Act. I think that's what it's called. The one from the 80s that says that, you can sue for all other drugs but not vaccines. It's all going to change. And they've got that DOGE, what's that, Department of Government Efficiency happening. It'll slowly trickle down to this place. It's just not going to be overnight. And it'll probably be just as slow as the leaky building problem that people had to go through,
I do agree, Erika. I think this is the whole point here is that, yes, we have to just keep chipping away at this. It is a slow process, but I also think if I could just add, I would imagine that there's a lot of companies out there, and I say we've all probably worked for some or visited some that were absolutely tyrannical about enforcing these rules. I do believe a lot of them are going to be thinking twice because they're already going to have been hit in the pocket, and they're going to realize it's not so smart to listen to the government or work safe without really any proper cause or proper legislation. I really do believe people are going to start looking and scrutinizing more than what they did. Because to be honest, we were totally fobbed off so easily. Everybody just complied, and I think that's the biggest thing. We all just complied.
Yeah, and there's one big company that I heard recently, Sony. They didn't mandate, for example. You know, there are some companies who have leadership who said, no, not a good idea, right? It's, what's it called? The Stockholm Syndrome, when you're all locked, you're all held hostage. And then you start feeling sympathetic towards the person who's holding you hostage. That's exactly what happened in Auckland. And it was that Juno, what's his name? Henry. The one who used to be on TV3.
Paul Henry.
Paul Henry, yeah, he was the one who said this is the closest thing to the Stockholm Syndrome I've ever seen. And I was like, wow, there's some insight from a Juno.
Would you say the media is the biggest issue?
Oh, they're one of the issues because they're not, you know, I just shared that screenshot of how many cases that's just the number 8 union, you know, let alone all the cases from NZD, SOS and the Defence Force. And there's so many that have happened in the last couple of years, and they're just not getting any publicity. Lisa.
Are the cases, so you've got private employment, are those cases going through faster than the ones like, say, you've got teachers or health, which are basically government, who, you know.
Faster. They're all about the same pace, to be honest, Lisa. Obviously, the Ministry of Health is probably the most obstinate in the sense that they've got a vested interest in sticking to their story. Yeah,
and delaying the truth coming out because it incriminates them.
I mean, they bought 18 million doses. I did an OIA and said, you know, can I see some details, please? And they said no. Well, as you know, and as John knows, they won't share details about the contract. But then I said, how many doses did you buy? And they told me within a week, 18 million. Like, they were so proud to tell me.
Yeah, we got to be really careful how we ask the questions in OIAs because you can get some really juicy information. We've already been down that road, but yeah, it's interesting, isn't it? So I guess how much time are you spending on this? Is this like 20-hour days for you, or and how did you get here? How did you get involved?
I used to work in IT. I still do some IT, and yeah, I'm doing this pretty much full time. How did I get here? I guess I've been in the corporate world for 20 years, and you start reading the Employment Relations Act just as when something funny happens at work, it's like, hang on, are they allowed to do that? Are they allowed to do this? So it's really just interest. And then all of a sudden, when I wasn't allowed to go to the hairdressers in March and get my hair done, and then now their leaders on television with hair and makeup, I'm like, well, what's going on there? How come she gets to go to the hairdressers and I don't? Like,
that was one of the biggest ones for all the ladies here. The fact that we couldn't get our hair done and how much that was a big awakening for most people, wasn't it? Hair and makeup and getting your general beauty stuff done. Everything went kind of haywire, didn't it?
Well, yeah, I thought of Napoleon and Snowball of Animal Farm. What's going on there? They're off dining with the humans.
You see what happened to us poor hairdressers when our clients came back, what they'd been doing to their own hair. It was traumatic.
Traumatic. It was traumatic what we had to wake up to each day too,
Yeah, when all of a sudden there's this rule and it only applies to some people, then something's not quite right. And I think I spent decades paying my taxes to be represented, and I didn't get represented at all. I got told I was going to die. I was going to use all the hospital beds. I was part of a pandemic of the unvaccinated. It's like, hang on.
Then why aren't we sick? This is why aren't we ever sick? We're never sick.
I worked in a retail store and they didn't even push the mandates. But, here I am working all around people and people are coming up talking to me at the counter and throwing their clothes at me when my hairdressing business went a bit before the salon and all the doodah. So it was kind of like, wow, really interesting. And I'm thinking, and I had to use a public toilet before the vaccination. So where's the mandate? Where was all the biohazard bins for the masks and the,
Mm.
you know?
Yeah, that's very interesting you say that, Tanya, because there's a testing order, another piece of wonderful COVID secondary legislation, and that didn't get revoked until, I think late in 2022. So they introduced a vaccine order. There was always a testing order.
Oh, wow.
And that's actually in, well, I mean, the vaccinations order has nothing about firing people either. It just says you have to be exempt or vaccinated for certain roles. It doesn't say you can fire anyone. They didn't start saying you could fire people until the 26th of November 2021, when they added this section and provisions relating to COVID-19 vaccinations, inserted 26th of November. So all those people who got fired before then, there was nothing in the Employment Relations Act to say that you could get fired. And it says that you can still be tested. So if you're termination of employment, we've still got, you have to be either vaccinated or undergoing medical examination or testing. Some workplaces, they were taking your temperature when you walked in the door, and then all of a sudden they said, "Oh no, we can't do that anymore. You have to be vaccinated." Well, that's actually not what's in line with here, because you can't fire someone unless you haven't agreed to do all of these things, right? Geraldine, you've got your hand up.
So the takeaway from this, Erika, for everybody else out there, from what I can see here, now, some people, reading legislation is not their thing. It's like looking at fine print in a contract.
Yeah, it is.
However, if you really look at the whistleblowers one in particular, if you look at that one, and you, just a little bit of information that you've skimmed through here, basically with that and the COVID response, just those two bits of legislation, there has been, I would say, employers have been gaslit and lied to by the government because they didn't go and do their due diligence and look at what they were, what their, I suppose, their obligation really was and what their obligation was not. And so a lot of companies, I guess, are going to be paying the price for not doing their due diligence because of that, because of compensation, payouts, etc. So the takeaway, I guess, for everybody is always go and look at what does the legislation say. The average man on the street is not going to know. Look at businesses that were duped. To be honest, a lot of them could have done things differently if they had read the legislation correctly. And so for us, I guess, now that we've got the Whistleblowers Act that you have been working with and being successful with, possibly to get more people on board there in order to create awareness as to what your rights actually are if you were in that position and you are in that position to be able to do something about it for, I guess, yourself and other people out there. I mean, Barry's case in particular, he's, what you're working with at the moment, fair enough, part of it's in the criminal jurisdiction, but a lot of it is actually his employer that is going to need to be accountable for this. So for us as a group, this is about educating and also feeding people into the direction of people that are there for them. And I think that's the work that Number 8 is doing. It's you doing work for the people. It's not for any other reason but to bring justice and bringing the right to fix the wrongs, even though it may not at this point. But that is why we've had our group meet with you tonight to bring this all out in the public forum, because a lot of people are not aware of this. So, to put them in touch with the right people. We know that the unions did not work for their members during the COVID era, so to speak. And they're not doing it now either, especially in healthcare. They're still staying silent on what's happening and what's happened, and they never ever going to back down on that. So we will definitely
they will have to, they can't pull this charade off forever.
well, as long as I think the thing is, as long as the people carry on playing the game, it's going to carry on. And
but it takes a couple of years to get a case through. So we've got quite a few cases lodged against DHBs and other health providers, and they're still in early stages, Geraldine. So
do you think that
watch this space?
do you think that putting a class action in the ERA the way you guys do it initially, or do you think everybody still needs to do an individual a personal grievance, etc., or do you think collectively it has more traction, or no?
So everyone has different. There is no cookie cutter. One thing employers did very well was isolate people, right? They didn't go, oh, Sarah, you're the same as Jane. You two both don't want to get jabbed. Let's have a meeting with both of you. They never did that. They always isolated people, and people's communications and timeline and what happened is all different. So each one has to be dealt with on a case by case basis. And unless they're all terminated on the same day and they all got together and stood up as a group. We do have a couple of groups that all acted together, but most people were isolated, and this is sort of the character trait of an abuser and the abusee, right? The abuser goes, John, don't you tell anyone about our little secret. No one else is going to find out about this, and don't go talking to anyone. And it's all very, it's like some kind of playbook from an abusive novel in my view, and they're all going to have to be dealt with on an individual basis.
Right.
And unless there's a whole group of people, say, all on one team and they all said something, and they all did it at the same time, but it really is a case by case basis. Now, like I said, we've got a lot of cases against a lot of DHBs. As you know, they're not able to spend as much crazy money as they did before, so they can't keep on forking out the lawyers forever, right? To slow things down.
So do you think a lot of those would be settled prior to going to the court?
We have had a couple settled before going to the Employment Relations Authority, yeah.
But those would be the ones that were mandated out and lost their jobs, correct?
Yep.
Right. Okay.
So when whistleblowers, we need more whistleblowers, right? Very Young's our only whistleblowing case at the moment that's in the Employment Relations Authority as a personal grievance, and it's still very early days. Anyone who's seen wrongdoing in their profession, and I gave examples before. If you're a osteopath and all of a sudden you're told that you need to take pharmacy, well, that's breaking your own code. Those kinds of things need to be raised. Otherwise, like what Brian was saying before, they're just going to keep trying this stuff on. If you keep on complying, then they'll just keep on trying it more and more and more. It's not really dissimilar from some kind of, drug mafia that are just going to keep on pushing, and they don't want to follow the law. They don't want to follow the courts. They don't want to follow all the existing frameworks and systems. They just want to keep pushing their product and getting their profits, right?
I think there's a lot of people out there that are actually know they've been injured. They know that their health is not good. I mean, if they could get together with other people in the workplace, or with a work, they could work together and do something about it, could they?
Yeah, totally. And I mean, they're all going to have different diagnoses, probably, right?
Yeah, that's the thing. But it seems,
and they'll have different dates of diagnoses. But yeah, I mean, There's nothing wrong with having people, you know, more than one person with the same claim.
Makes it a bit
Um,
easier. Mm.
There's a lot of ACC accredited employers, and people are making ACC claims as a treatment injury. There's also the ability to do a workplace injury, and that's already been through the Employment Relations Authority. A guy got that, what was his name? Oh, I want to say Lavender in Air New Zealand. He got his employer because he got a claim because he caught COVID from his Air New Zealand flight from China back to Auckland.
Wow.
And he's got a claim. He's had a successful claim against Air New Zealand as a workplace. It's a workplace claim. So yeah, these are the things that our wonderful media don't talk about. These cases that have happened. They're all on the ERA website, all the courts website. You can find them on there. You can do keyword searches for vaccination, and you'll see all of the cases come up. It's sort of really up to you guys or everyone really, to talk about this kind of stuff, you know, especially when you talk to employers and say, so how did that work out for you, pushing all that on all your staff? How many sick days did you end up having to pay out for COVID sick days? You know, do you think the measure that you took was successful? Do you think it worked? Did it stop your staff from all getting sick? You know, if a workplace pushed jabbing and there's 100 workers and all of them took COVID sick days, then I'd be pretty safe to say that it wasn't an effective measure.
Yeah, it's funny that, Erika, on that subject, I attended a meeting with the company, and one of the things on the agenda was that they were asking the union for a bit of assistance to understand why they've got such a high level of sick leave and unplanned leave. And well, I thought, geez, I better bite my lip, yeah, because yeah, you know what, I just wanted to jump up from the table and shout, you know. Anyway, they carried on for about 5 minutes, and they're going this way and that way with it. And eventually I said, well, have any of you perhaps realized or thought about the fact that maybe these people actually were sick, that there's an increased level of illness? And have you noticed the cancers in the company, people getting cancer and, you know, heart failure and all this? And, you know, instantly they knew which avenue I was coming from. And that's it. The conversation just ended. And it's, yep, time's up, moving on, next item on the agenda. You know,
Do they pay health insurance for these workers?
No, we don't have health insurance. We've got a life insurance policy.
Oh, okay.
Yeah.
And then did they pay COVID? Yeah, I'd ask them to distinguish between regular sick days and then COVID sick days.
They did offer COVID leave. If you had exhausted your sick leave or whatever, and you had COVID for a second time or whatever, they would pay discretionary. I'll give them that. But the thing is, they're very hesitant the minute you ask for these stats, you know, because typically that would be my question. Oh, well, can you put some figures on the table so we can also see, you know, what is going on here? Oh, no. They are so hesitant, man. And, you know, probably that gets back to your point earlier on about the whistleblowers. This is where we need whistleblowers, you know?
Yeah.
Somebody in a department there that can go, man, I've got definitive proof that all of a sudden our illness has just kept climbing through the roof. And it kind of winds up with people going and standing in the queues for the jab. But yeah, it's
like if you were to implement any other kind of measure in a workplace for safety, like, you know, if you said, all right, everyone on the construction site has to wear, I don't know, I mean, like those yellow vests, say you got to wear a yellow vest when you're on the construction site. How often do people actually get hit with something on the construction site? I don't know. But if people were still getting hit with yellow vests, then you'd go, well, maybe the yellow vests aren't working. Maybe it's something else. You know, you'd actually look at what it is that you've implemented to see whether it's been successful or not.
That's right.
And that's part of the health and safety rep or the health and safety job, right? the person, the manager.
Yeah, yeah, that's right. Erika, look, I thank you very much. I'm looking at the time at the moment, and gosh, we've really had an hour and a half already of good talking here. I must admit, you've covered such a lot, and there's still a lot more that I would have wanted to raise with you, but you know, I'll let you go easy. I just wanted to check with anybody. Was there any last questions for Erika before we go? I will just add something. People that don't know Erika, she is a prolific Official Information Act requester. Erika, you must be over the 130, 140 now.
Yeah, 100 and something, 160 maybe.
Oh,
But I mean, anyone can do these, you know. You just gotta go to fyi.org.nz and start asking.
yeah, you've done some good ones. Yeah, there's been some really good ones there. But yeah, I'd probably just like to end off and thank everybody. Thanks everybody for the group getting together and for listening to Erika. Erika, thank you so much for your time tonight. I appreciate it, and I urge all your viewers to go to your website. With your permission, if it's okay, I'll below the video description, I'll put all the links to your website, your Facebook. Are you on Twitter at all?
Oh, we have one, but we don't really. We're too busy doing cases to be marketing, to be honest.
Okay.
It's pretty much word of mouth at the moment.
All right. Well, then I'll put the union's details. Can the viewers, people out there that need to get in touch with yourself for any employment matters or whistleblower matters, is there an email address on the website or?
Yeah. So there's an email address on the number8.org.nz website, and that's where you can ask questions about joining or whistleblowing or whatever it is that you want to find out about for making your workplace safe.
Absolutely. Oh, well, thank you very much, Erika. And thanks, everyone.
Thank you, Erika.
Thank you.
Thank you,
See
Erika.
ya.
Lovely to
Bye.
talk to you all.
Thanks,
Yeah,
Erika.
you too.
Good night.
See you later.
Good night.